everyone. I'm Sydney Forsander, an attorney in Husch Blackwell's Intellectual Property Group. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We'll try to answer all the questions during the webcast today, but if a fuller answer is needed or we run out of time, we'll answer those later via email. A PDF of the presentation is available in the program materials folder. And this program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of this webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's all for housekeeping items. Let's get started with the program. I'll turn it over to Kathy to introduce herself.
They told me I'd forget to turn the mute off. Okay, hi. Good morning, afternoon, everybody. This is Kathy Rankin. I'm senior counsel with Husch Blackwell. I am a registered patent attorney with a degree in biochemistry. However, my practice has in recent years been focused on all aspects of copyright and trademark work, including client counseling, opinion work, prosecution, licensing, and also with work in enforcement, both with enforcing client rights and helping them respond to cease and desist letters. As you already saw, presenting with me today is one of our superstar associates, Sydney Forsander, and she will introduce herself a little bit further, and then she's also going to take the first couple of slides. So Sydney, back to you.
Thanks, Kathy. So as I mentioned, I'm an intellectual property attorney and a licensed professional engineer. My background is in electrical engineering. I work with both domestic and international clients of all shapes and sizes to protect and manage intellectual property rights across industries and around the globe. I typically focus on patents related to emerging electrical, electromechanical, and software-based technologies. I also help advise clients with developing comprehensive IP strategies, including their copyrights, patents, trademarks, and open source software licensing compliance and music licensing, like we'll talk about a little bit or a lot today. So we have a lot of ground to cover today. Our agenda, we're going to go over some basics of copyright law, how music works in business, the different types of music licenses, considerations for whether or not you need a license for your use. We're going to talk a bit about DMCA and some Creative Commons and alternatives to music licensing. And then we'll wrap up with some compliance and practical pointers for you to implement this, hopefully in your day-to-day. So first, what is copyright and copyright law? Copyright is a type of intellectual property that protects original works of authorships, which means things that aren't copied. And they have to have a minimal degree of creativity created by a human author. These have to be fixed in a tangible form of expression. So what the heck does that mean? It might be easiest to talk about things that are not covered by copyright. Brands, short phrases, slogans, those are things covered by trademarks. The underlying ideas, methods, systems, processes, those are things covered by patents. And then works consisting entirely of just information and facts, including laws and statutes or just basic forms, also not covered by copyright. And you might be wondering how much creativity has to be a creative work. It turns out not much. The Supreme Court has decided that the level of creativity needed to fall under copyright protection is just a spark or modicum of creativity. So the bar for creativity is very low. And then fixed means that it's captured in a sufficiently permanent medium. So as soon as something is written down, it's fixed. Or if it's recorded, it's fixed. So for instance, if you're humming while you're walking down the street, and nobody's recording you, that's not fixed. Same thing if there's a live performance of your music happening and no one's recording it, also not fixed and not covered by copyright. So who owns copyright? The author, initially. If you're working for an employer as an employee in the scope of your business, then your employer owns it. But originally, the author, the person who creates and fixes the work, is the owner of the copyright. And recognize that for music, even creating a song or a play, there could be lots of authors involved. And as we'll talk about, you need permission from each of the authors for each of the rights. And again, there's a subcategory for working for an employer called a works for hire if you're an independent contractor, or that line between whether or not you're an employee or working for your employer that we're not going to cover in the webinar today, but just know that it's out there. And also that your ownership of the copyright and the part of the ownership that you own can be assigned. So copyright means that you have these 6 exclusive rights as the copyright owner. And again, the owner and author, you can have multiple. So first, you can reproduce the copyrighted work. This means that you have the right to stop others from making unauthorized copies and distributing them. You can also display the work publicly. It's not so applicable in music. That's mainly in the visual arts and literature space. You can distribute copies of the work to the public, similar to number 1, which also includes streaming for music. But on the music composition side, when you think about the underlying sheet music, that's mainly selling the sheet music. You can perform the work publicly, and recognize that this doesn't necessarily mean that you have to be doing a performance. That can also just be playing the music over a speaker in a public space. And 5 is what they call digital performance rights. It's mainly for radio and only applies in the US, which this is a great opportunity to say that we are only covering copyright as it pertains to the US only today, not covering international works. And then finally, you have the right to prepare derivative works, which a derivative work is a musical work in this context, or a copyrightable work that includes major components of previous original copyright work. So you're changing it and making a derivative of a major copyright work. These 6 rights are important because this is how artists and creatives make money off of their work, by having these rights and being able to give people permission in exchange for payment or royalties for these rights, especially in the music space. So that comes into copyright infringement. It's doing any of those 6 rights without the permission of the copyright owner. And it's especially important in the music context because, again, that's how musicians make their money, by getting royalties from permission to use their work in different applications. So I'll turn it over to Kathy to talk a little bit more about music everywhere.
Yes. Today we're focusing on music. And as we all know, music is everywhere. You can't hardly go somewhere without hearing music. You've got your radio in the car, you've got the music in the grocery store, the music playing in your gym. Certainly you're looking on your phone, there's music in the memes, and certainly everyone knows the way music is used on TikTok. And this music is a cornerstone of advertising. It can be used in so many ways to improve your business. If you have a bar or a restaurant, you can have a karaoke night. The music that's used there will require a license. You can also have the music in your background store. Depending on the music that you use, you can encourage your customers to stay longer if it's creating a pleasant environment. You also need to have good hold music so that you can get people to wait until you've got an opportunity to deal with them. Music is also used in advertising, television, radio ads on your website, social media, backgrounds for live streams. The right music can make your ad a success, or it can have it be a flop. So you need to be sure that you're determining what music is needed to make your ad work. Scientific studies have shown that the psychological impact of music on advertising is great. If you use the right music, you can get more people to buy your product. You can get people to stay in your store longer. A Texas A&M study showed purchase intention, specifically with sports-related advertisements, is increased with the use of a vivid rhythmic music selection in addition to dynamic sports images. Similarly, you want to tailor your music to your selected demographic. You'll use different music for selling tuxedos than you would in a country western store. So all of these things go into the choice of the music you found you're going to use. But now you say, okay, I know the perfect music. I know exactly what I want to use. So let's go ahead. Let's put it on the recording. Let's get started. But the question is, not so fast. The music's everywhere. You can download it. You can upload it. You can stream it. But you can't just use it however you want. Unless you've created your entirely own original music, you're going to be using music created by someone else. and that means the music will be covered by a copyright owned by someone else. We want you to assume that any published music that you come across, even hand recordings or handwritten sheet music, is all subject to intellectual property and copyright laws. Unless you very specifically make a determination that it's in the public domain, you should assume that it needs to be licensed. Now, is music copyright different than regular copyright or copyright in general? Certainly, the basic tenets of music copyright law are all the same. However, music copyright and music licensing can become very complex. With a musical work, you've got several layers of protectable elements. You have the sheet music, which was written by the composer, and the composer will have his or her copyright in that music. You then have the lyrics, which could have been written by the same person or different people. And there is another copyright that applies to the lyrics and as they're used with the music. And finally, you take the sheet music and the lyrics and you find a band or a singer-songwriter or whoever it is, and they make a recording. And there is yet another copyright that attaches to that recording. And so once you have the music you know you want to use, you need to determine who each of these people are. Who is it that has the rights to the music, to the lyrics, to the recording? Sometimes there's been an assignment of those rights all over to a record company or all over to a publishing company, but that all needs to be found out. And the same thing we need to note is if there is a recording that uses an old piece of music, it uses Beethoven's Fifth Symphony, but it's a new recording by the Chicago Symphony Orchestra, that recording has copyright, even though the underlying work is in the public domain. So you need to look at all of the layers in order to determine who you need to contact for your license. So now you know the players, so it should be all downhill from there. Unfortunately not. Copyright licensing also is determined by the type of use that you will be using. There are 6 main types of copyright licenses which apply to different forms of use. Now, in this discussion today, we have not attempted, and we certainly would not be able to, discuss every possible combination of licenses needed for a particular project. For example, often a performance license is needed to publicly broadcast your advertisement. However, that advertisement also needed a sync and a master license. If you have a podcast that you're live streaming, you need a performance license for that. But if you allow it to be downloaded, then you need what's called a mechanical license. So we'll talk about the different types of licenses. And once you determine what your project is, it would be easier then to determine which licenses you're going to have to obtain and from where. Okay, we've got our first poll question here. Just determining where you each do your different advertisements. So if you could just take a look at those and let us know. We'll give you a couple seconds. And I'm going to turn it back over to Sydney. Let's see, I think that's good. Let's see what we got here. Did I not wait long enough? Nobody
Maybe not.
answered.
Oh, there we go. Okay. We'll give them another second. I think we got some
Okay.
coming now.
Oh, sorry. I jumped the gun.
All right, a couple more seconds. Go ahead and submit your answers to the poll question. All right, now we can move forward. We got some there. All right, something else. Be interested.
Quite a few something else.
I know. I'd be interested to what did we miss?
Maybe it was radio. We did forget radio. So
I did.
perhaps that's radio.
Okay.
All right.
We thought that it'd be good to kind of cover some of the common misconceptions before we dig into more license details, which I'm sure you're very excited to hear more about. We've all had that friend on Facebook or seen the Facebook post where someone says you post a cute little video and there's music in the background and they say, I do not own the rights to this music. Unfortunately, that's not going to get you out of copyright infringement. If anything, it's admitting that you know that you're copying something that you don't have permission to copy. So leads to some of the common misconceptions, specifically in music when we use it, that attribution or a link to the source is enough. And that's not always the case. You need a license. Some of those licenses allow just for attribution, but it's a very specific, a specific application. Another thing, sometimes people will think, oh, the creator made it and posted it for others to share. They want to go viral. It'd be great for their business to go viral. While all of that may be true, that doesn't negate the fact that the content creator is the owner of that copyright work and that they have those 6 exclusive rights that we mentioned before. So you still need permission, even if it would be great for them if they went viral. Some people think it's just very simple. This design is not covered by copyright. As we talked about at the beginning, the threshold for creativity that's required is very low. So don't assume that just because it seems like it's not that creative and you could have come up with it yourself, that you're allowed to do whatever you want with it. You still need permission. You may be thinking, worst case, I'll go ahead and post it. I don't have permission, but licensing is a lot of work. Worst case, I'll just take it down. I'll get a takedown notice if somebody complains. That may not be the worst case. Someone can sue you for copyright infringement, in which case there are statutory damages available, which means that they don't actually have to show harm in the sense of profits and losses that were affected just by you infringing the work. Statutory damages are available. You might be thinking this song is super old. I can use it. As Kathy mentioned, the recording of that song is probably not in the public domain. And so just because the song or the sheet music itself is old doesn't mean that you can use it without re-recording it yourself or getting a license for the recording. And then fair use, you may have heard this before. It's a complicated legal doctrine. It's got multiple factors in it. It's not just, I want to use this, that seems fair. And it also doesn't come down to just a commercial, non-commercial use. While that is one of the factors in the fair use analysis, that's not dispositive. And it also doesn't depend on what type of entity you are. So don't assume just because you're a not-for-profit entity that you get to use whatever you want under fair use. That's not a good assumption. If you're going to rely on fair use in order to be able to distribute copyrighted content by someone else, you need to make sure that you have legal analysis for that. And the bottom line of all of these misconceptions is if you're working on a media project or a multimedia project for your business or a client, especially if you're using copyrighted content in something you're creating for a client, like a wedding video with background music, never use unlicensed content. Always make sure that you're getting permission. Your video might get muted or taken down, but it could also result in legal action and a bad reputation for your business. So you just want to make sure that you're following the rules and you're staying compliant. And out of all of this is a quote from the authors of my copyright law book from law school. No area of copyright law is more complex or productive of more controversy over recent decades than the tangle of copyright rules and industry practices that govern the music industry. So if you thought it was going to get easier from here, not quite. So I'll turn it back over to Kathy to talk about the different types of music licenses.
Okay, great. As I mentioned, there are 6 main types of music licensing in the copyright field. This slide shows the first 2 that are often obtained together. You have a sync license, which is used when the music is synced or played together with audio visuals. So obviously this is movies. It also includes television or other forms of audio visual advertisements. This license is obtained from the owner of the underlying musical composition, so that sheet music and those lyrics, and you get them a sync license from them. And then if you are using their music but you're recording it yourself, then the sync license covers what you're doing, because that allows you to do a cover recording of the music as well. If you are using the pre-recorded work, then you also need what's called a master license. The master license, like I said, it covers the song, the recording of the song, and is needed in addition to the sync license. And you get that from the owner of the recording, which is most often the record company. You can get combo licenses for sync and master together if they happen to be owned by the same entity, but oftentimes you're looking at two different owners, so 2 different licenses for yet same piece of music. Now, the other thing that the other 4 types are useful themselves. in different scenarios. The public performance license, sometimes you need this together with a master and a sync license. You need it if the advertisement or the audiovisual work is going to be publicly played, whether it's going to be on broadcast television or played over the radio. That song is being publicly performed, and so you need a performance license. Performance licensing also covers background music and hold music, jukeboxes, any other type of music where it's played out to the public. And a performance license can be obtained through, there's various organizations that collect libraries of music to allow for easy, more simple performance licensing. I'm sure you've all heard of BMI, CSAC, ASCAP. These are performing rights organizations, and they manage libraries of music, and part of the licensing with them is they keep track of the number of plays of each song, and then your cost is per play as royalties. And this is where singer-songwriters, musicians are collecting royalties when their music is played in various forums. So you need to contact these organizations. They each have their own library of music. A license with BMI does not give you a license to CSAC's license, library, etc. You can license single songs or groups of songs, genres of songs. They have different levels of licensing. And in some instances, you can get a flat fee license where you pay, it's called a blanket license. You pay for a certain group of music. You pay a monthly fee, and then you don't have to track the number of times it's actually played. Now, the next license on here, we mentioned briefly also, is a mechanical license. You need that to manufacture CDs or DVDs or to have music downloaded onto a hard drive. Anytime you are making a copy onto a physical device, you need a mechanical license. You also need a mechanical license to record a cover song. So in that case, you would need a sync license and the mechanical license to perform and record your cover song of somebody else's music. Generally, you can have either the publisher or the songwriter may hold the mechanical rights. It's something you're going to have to determine. It's not automatically set. Usually there's agreements with the singer-songwriters. A lot of times you hear complaints like Taylor Swift's recently that, you know, the record company is holding her music and won't let her use it. It's all determined by the contracts that were signed at the time the music was made. And payment, like I said, it's generally a royalty for mechanical licenses as well. And then print license is mostly for sheet music and lyrics because it's a physical print, paper copy or reproduction, doesn't have to be physical, can be on a computer screen of sheet music and lyrics. Sometimes this comes into play if you have a songbook or if you're doing a sing-along and you reproduce the music for either personal or public use. The last license here is probably not as well known. It's a theatrical license. And as the title seems to indicate, it's necessary if you're performing a dramatic performance on stage in front of an audience. So a play, musical, a dance, an opera, narrations, etc. Okay, is there ever a time that you do not need one of these licenses? Perhaps, but not often. Again, if you have created the lyrics and composition and recording all on your own, then certainly you don't need a license for that. If you use public domain music and you do a performance and you record that performance, that you don't need a license to use, it's yours. If you have made a definitive determination that the work is in the public domain, that is absolutely free to use. And in some instances, the platform that you're using has licensing built into it so that you don't have to obtain your own, but you need to be sure you are following all of the rules that are associated with that platform's library. The YouTube audio library has things you can use for YouTube streams. Facebook has its own, each of these here, but you have to follow the rules. If you're a certified Zumba instructor, you can use Zumba music in your exercise classes, but they have to be Zumba classes. You can't take Zumba's music and then use it in a class not associated with Zumba. So you need to be sure in these types of platform usages that you are following all of the rules, or you're outside the license and you are infringing. Okay, so you need a license. There's no way around it. So what do you do then? So we've talked about you have to find who all the rights holders are. You need to contact the rights holders and ask them, will you give me a license? Sometimes they say no. And sometimes, if they agree, they'll send you the terms. Depending on the work and the artist, it could be something you can negotiate, or it could be a take it or leave it type of situation, depending on it. And then once you have the license in hand, you need to be sure that you do what it says. Finding publisher information, you can sometimes find it on the recordings. The PROs, ASCAP, BMI, and CSAC maintain databases with publisher information. So even if you're not getting a performance license, you can use their resources to determine who you need to contact for the sync or the master licenses. Okay, we've talked about a lot of this already. And also with PROs, these aren't the only ones. As it says here, they do have 95% of commercial music options, but there are smaller PROs that have tailored libraries. You can find a PRO that has libraries specifically geared towards elevator music or hold music, or they have background music licenses, and that may be a less expensive option if that's what you're doing. There's also niche PROs. For example, there's the Christian Copyright Licensing International. It's a company that provides performance and also can assist with sync and master licensing for a library of music used by churches, schools, and similar types of organizations. So you can look around, find the PRO that will best work for you and your performance license needs, and determine what their terms are and go forward from there.
I'll take over from here, Kathy. If you've just listened to all of the licenses and the process for getting a license, if you need one, and you're thinking to yourself, nope, this seems like a lot of work, I'm just going to risk it. Technically, you can. We don't recommend it, and there may be consequences. So if you decide you're not going to comply with getting a license when you need one, you risk your content getting removed. Your profile may be restricted. Depending on the platform, sometimes they have a 3 strikes you're out, sometimes first-time offenders. And again, your reputation as a business for putting out content, especially if you're creating content for clients that include unlicensed music, but also just your reputation as a business generally, if you're getting hit with all these takedown notices because you're not complying, that's going to impact your business as well. And then, like I mentioned before, a takedown notice is not the worst case scenario. Someone can sue you for copyright infringement in federal court. And typically it's expensive to bring a copyright suit, but it happens, and it happens every day. And so you can get a demand letter. And then, as I mentioned earlier, there can be statutory damages where even if you're thinking, oh, I'll share this, it's not affecting anyone, it's just this small little thing. Statutory damages for infringing work, you don't have to have harm shown. And then obviously you can get, if you are harming another entity, company using their copyrighted work, there are additional damages as well. So most of you, if you've been operating in the digital space, you're on a webinar, so I think that's everyone on here, at least to some extent, has probably heard of DMCA. And if you don't really know what DMCA is, it's a law. It's the Digital Millennium Copyright Act. It was enacted in 1998. And this was a major overhaul to copyright law, specifically geared towards the new concerns in the internet age. The most significant, arguably the most significant changes that came out of the DMCA is there's an established notice and takedown system. And this encouraged content owners, a wide dissemination to content owners to be able to control and protect against unauthorized access to their works that now can be shared even more easily now than it was when it was enacted on the internet. Another thing, if you've noticed those annoying copyright watermarks on images, you're looking on the web, you found the perfect one, you can't remove that watermark without violating DMCA copyright law. That's part of what came out with that. And then a note here, we're not going to go into it, it's outside the scope of this webinar, but there are safe harbors in the DMCA specifically towards ISPs or OSPs, internet service providers. If you're hosting a website where content is shared, if you're the YouTube or the Instagram, it's a safe harbor because you are probably not the one infringing. It's the people uploading content that are infringing, but there's a lot of steps and details that you have to follow in order to stay in that safe harbor. So again, just wanted to mention it in case that applies to you or your business, to flag that there is a lot of other requirements that you have to comply with in order to fall in the DMCA safe harbor. And then recognize that to be able to send a DMCA notice, or if you receive one, the work doesn't have to be registered at the Copyright Office. As soon as something is fixed as copyright protection, you do need to have it registered in order to bring an infringement suit, but not in order to send a DMCA takedown. And so you can either send this to the person who you believe is infringing, just to them, and see if that kind of expedites the takedown, or you can also send it to the source, the site provider, the ISP, the OSP, or you could send it to both. Recognize DMCA only applies to the US. There are proposed changes to the DMCA that may apply internationally, but those have not been put into effect yet. And then also recognize copyright law covers a lot of things. DMCA also covers a lot of things, but not all the things that are covered under copyright law. So most of the things that you'd be imagined that are shared online and subject to copyright frequently are covered under DMCA, but just to note that it doesn't cover everything. And if you see someone else copying your work without your permission, the DMCA takedown process is standardized. There are forms available. You can have an attorney draft it up, but there's just a few basic things that you need to include here. I'm not going to go through it in detail, but basically a statement of, here's my work, here's the infringing work. I believe that they're doing it without my permission, sign it, contact information, etc. And then if you receive a takedown notice, the most important thing is don't ignore it. Even if you don't believe that you are infringing or that you've done anything wrong or you had no idea, take down what's the content that's included in the notice. There's a process for filing a counter notice if you disagree with the DMCA, a lot like the same steps for initiating a notice, but you can't leave the work up just because you disagree. You actually have to take it down. And then just some notes on enforcement trends. We're seeing increasing numbers of DMCA takedown notices. Google has reported over 5 billion URLs delisted, and Twitch in 2021 had 1,000 in like a week, a big batch that came through. And so it's happening more frequently. And a lot of the times they're using artificial intelligence. YouTube has an AI platform that automatically checks and detects for copyright music in the work. And you may have a license for that, and YouTube may still flag it and issue a takedown. So again, don't ignore the takedown notice, take it down, issue the counter notice saying, hey, I had permission to do this, or I'm not violating anything. And you should be, that's the way to handle that. And then recognize that a DMCA violation can carry heavy civil and criminal penalties. For civil penalties, you can have damages and legal fees. The minimum fine is $750 per downloaded file, which can add up pretty quick. And then criminal penalties, even for first-time offenders, can be stiff, up to $250,000 in fines and 5 years in prison. So again, don't ignore DMC takedown notices if you receive them. And then I kind of mentioned earlier, there's some proposed changes to DMCA. It might make matters worse or better, depending on which side you're on. We won't go into details about those today, but it involves the international aspect as well. And then going into effect a week from Monday is the Copyright Office's new Copyright Claims Board. This is essentially a small claims copyright court to handle copyright claims of $30,000 and less. And that includes statutory damages, that includes however many numbers of infringing works are involved. And it's meant to allow pro se applicants and smaller content creators that don't have the resources to be able to bring a federal copyright infringement lawsuit to be able to pursue those claims. This is voluntary. If you receive a notice of the Copyright Claims Board, don't ignore it. You can opt out within 60 days, and then the claims would be dismissed, and the person would have to sue you in federal court if they wanted to pursue those charges after that. And this is also interesting because unlike federal court, you can be represented by a supervised law student or by someone authorized in your business entity. So just be on the lookout that this is coming. And if you are one of the small copyright holders that don't have the resources to bring infringement suits in federal court, this may be another option for you. And I'll turn it back over to Kathy.
Okay, so we've talked about all of this wonderful stuff. We've talked about licenses and how the different ways you have to pay all these people. And you're like, but I just want to make my ad. I don't want to spend a lot of money on it. Isn't there anything else we can do? And yeah, there are some other options available that can give you low or no cost music. They still require a fair amount of footwork, a fair amount of, there's no easy way necessarily to find what's under these. And the first one we'll talk about is Creative Commons. And here we have another poll question to determine whether or not any of you have ever used or heard of Creative Commons. And if you could just let us know so we can have an idea what's going on. Now, the last time I was told you guys weren't able to see the question until we clicked through to the answer. So, well, nope, looks like you're answering, so we're good now. Okay. Give you another couple seconds. And let's see what we got. Okay, so a fair number have never heard of Creative Commons. A good amount have used it. That's good. And so that's got a good handle on that. So let's see. Let's talk about it. Creative Commons. Creative Commons is a license. It is not that you can say, "Oh, this isn't Creative Commons. I can do whatever I want with it." No. The Creative Commons is a way to that people choose to license their work. There's no cost involved, but there is still a license document, and there are still license terms that you have to follow. If you are using a work under a Creative Commons license and you do not follow the terms of the license, then you are infringing, and you still can be held liable and sued for that infringement. There are 3 basic types of Creative Commons licenses. The list of 6 here, because each 3 comes in a commercial and a non-commercial. The most broad language is attribution only, which means you're required to say who the author of the work is and who the rights owner is. The way that the attribution should be presented is generally listed with the place where you find the work and where it indicates what license it is covered by. And as long as you have the proper attribution, you can use that however and wherever you want. You can make changes to it. You can make changes to it that you then keep for yourself. And that's all good. The next one that adds a layer is share alike. What that means is that they will let you use their work and change their work, but any changes you make to it, you have to also make available under the same Creative Commons license. So if you find a song that's under a creative share alike license and you change the lyrics and you re-record it and then you try to restrict the use of your recording, then you're in violation of the share alike license. You have to make that new recording and new lyrics that you put to that music available as Creative Commons share alike. The no derivatives is obvious. You can use it, but you can't make any changes to it. And then again, we have the same ones with non-commercial, meaning you cannot use it for a commercial endeavor. The final thing with Creative Commons is sometimes authors, they dedicate as a public domain work. And in this case, yes, it's in the public domain. You're free to use it however you want without providing attribution, although it certainly doesn't hurt to go ahead and give that anyway. So how do you find Creative Commons music? Now, Creative Commons, the website, has all sorts of information on how to put your work under a license and all the different licenses, but they don't really have a searchable database of everything that's been placed under a Creative Commons license. Creative Commons is currently working with WordPress on Openverse, which is where you can find images, but they haven't done the same thing with music. However, if you do Google searches, you can find other websites, SoundCloud, AudioNox, Infotech, that have libraries that are searchable, and you can find music that's covered under the Creative Commons license. You want to be sure that you confirm the license. If you find something that generically just says, oh, this is under Creative Commons, go ahead, you can use it, but it doesn't refer you to the original source or tell you specifically what license, you should be very wary. If it doesn't provide you with the proper attribution, then you certainly know you can't use it properly. So you need to be sure that you confirm it is under Creative Commons and what the licensing is. Commercial versus non-commercial. This comes up in a lot of areas of the law, and every place seems to define it a little bit differently. The Creative Commons website very generally says commercial means primarily intended for commercial advantage or monetary compensation. They're clear that this is not a legal opinion. They're not giving you a legal opinion. It's just a definition to help you out. And it does not mean that a not-for-profit company is always non-commercial, and it does not mean that a for-profit company is always commercial. You can have a for-profit company running a non-commercial activity or event, and that can use the Creative Commons non-commercial licenses. There is also an entire wiki page that they've got further instructions and information on how you can determine if something is commercial. Something that comes up fairly often is if you have a blog page, you're not selling anything, you don't bring any revenue in from your blog, but you do have advertising links and you are generating ad revenue, or you have links where you get kickbacks from the company. If your readers click on it, that is a commercial use. That is a commercial page. You are making money from the use of the music that you use in connection with your blog. So you need to make sure you look at all aspects of your use to determine commercial versus non-commercial. This page shows how the attribution is. Usually you've got the name of the work and you've got who it is, and you have to put there that it's licensed under which license. And then this particular work allowed derivatives, and so Sydney changed it a little bit. She changed the coloring, and she then also posted it and gave the attribution, indicating that she made changes and that she has licensed it herself under a CC BY license. And that's the way you do it. You have to indicate what the license is and how you're relicensing it. And all that information can be found on the Creative Commons website. Royalty-free music. Royalty-free music is not free. It means that you don't have to pay a royalty. You don't have to keep track of each and every use and then pay a certain amount of money for those uses. Usually you get a blanket license from a company that has a library of music. You pay them a flat fee, and then you can use that library that you've licensed however and as often as you want. You need to be sure that you know what the terms of the license are and that your use complies with the terms of that license. And then you just have a flat fee and you don't have to go through the steps of determining how many times you've used it. Those can often be cheaper, less expensive, depending on the type of library that you're licensing. Public domain, we're talking about this again. Public domain, everybody wants things to be in the public domain. In reality, it's very difficult to know if something is public domain or not unless it's very old. Musical works and lyrics from before 1926, sound recordings from 1922 or earlier. Otherwise, it's very hard to tell. There could be something from 1978 that expired and is in the public domain. But to determine that, you need to know a lot of facts. You need to know which of the Copyright Acts were in effect when it was published, when it was created. Was there a requirement for a copyright notice? Did they do a copyright notice? Was it under one of the acts that allowed for renewals? There's just a lot of information before you can definitively say something is in the public domain. The Cornell University Library has an 11-page PDF outlining nothing but copyright expiration dates based on various different factors. 3 of those pages deal solely with sound recordings. So it's a complex situation, and unless it's really, really old, you should assume it is not in the public domain unless you can find strong evidence otherwise. And let's see, there's a couple questions I'm just gonna take right now because they deal with some stuff that we talked about. Somebody asked how Taylor Swift was able to re-record her music if she didn't own it. And this comes into the different layers. Taylor owned the composition and the lyrics. She did not own the recordings. So she could not take her first recordings that she had and use them without the record company's permission, but she did own the underlying compositions, and therefore she could re-record it, and those new recordings she then owned. And then the question was relating to the owners. If there's joint owners or multiple owners, how do you know who you need to contact? A lot of times there's agreements. If there's not, then yeah, you do kind of have to contact everybody. Sometimes you can find out that, one has 50% and the other one has 50%. You can contact one, but you can't find the other. Yes, it's trouble. But if there are multiple and joint owners and there isn't an agreement saying who has the rights to license, then you do need to find everybody. And I'm going to turn this back to Sydney to go over some practical pointers.
Thanks, Kathy. Yeah, so we've covered a whole lot of law and facts and license options. And if you're feeling overwhelmed, it's a good time to take a deep breath before we kind of dig into these last few slides. Are going to go over some recommended best practices to make sure you and your business are compliant with music copyright laws, and some practical pointers on how to implement some of what you've learned today. So if you want to use music in your digital advertising, it's great to start early. Negotiations can take time, especially if you're working with a smaller artist. Otherwise, working through those agreements and figuring out your budget is very important to do early in the project. And it's a great idea to do a copyright compliance checklist, not just including your music, but also any images, texts, content generally that you can use from project to project. And this is a great idea if you're a small solo practitioner, small solo business, or a large corporation. And it can be great when integrating with teams. Even if you are starting out with just yourself, having that checklist before you post something, making sure that you're checking all those boxes. And then as you begin to grow your team, and make sure everybody's on the same page before you go through. And finally, you need to pick your music and figure out what license is going to work for you. And again, you may be able to negotiate those terms, or maybe the license you assumed that you would start with when you made the budget is not going to work based on how you want to use it. So you might have to be flexible. That's why the planning early comes in use. So understand the scope of your license. I know no one likes to read terms and conditions. I don't read terms and conditions when I download something either, but it's very important on your license, and especially when you're going to go through with a business, using this in your business advertising. And to verify at the end, it's a good idea, even if you've done it at the beginning through the negotiation. Again, a lot of these can take some time to kind of hammer out the music license. Before you post, it's a good idea to verify that the use that you actually license this work for matches up with how you're planning to use it in practice. And then finally, addressing takedowns promptly. If you receive a takedown notice, again, don't ignore it. Take that down, and you can address any counter notices as needed. And keep an eye out. If you see someone out there infringing your content, take steps to enforce it, whether that be a demand letter or issuing a takedown notice yourself. And then some tips specific to YouTube, again, can apply to multiple platforms. It's great to make your own music, both the underlying written composition and the recording, or to use the embedded libraries that platforms offer. Because again, those have licensing in them and you don't need to get the separate license. I also think it's useful to understand that if you're gonna live stream or host live videos, you need a license if you're gonna do that on your own website. But if you're doing that through Vimeo, Twitch, YouTube, Facebook Live, those have BMI and ASCAP agreements with those platforms specifically for the live aspects. You don't need a separate license for that. But recognize, like we've talked about before, if you're going to archive those videos, allow them to be downloaded later, that may implicate separate license requirements, especially if you're using, like I said, your own website, or you have an application related to those rather than just through the live platform use itself. And then we mentioned earlier that YouTube has automated systems for detecting these, and they're pretty sophisticated, but they're not always correct. So if you do have a license obtained, you can use that in your counter notice to say why it shouldn't be taken down and why it was taken down by mistake. But make sure you take it down ahead of time. Another option that YouTube does specifically, again, each platform can have different policies related to its takedown. It can either take down the content It can mute the audio of the content altogether, but leave it up. It can block your profile. YouTube does this after 3 violations. And it can also notify the actual copyright owner to be allowed to monetize off the content that you created, which means that you cannot monetize on it. So again, this is YouTube specific. Each platform has its own rules and stipulations. Make sure you understand those and you follow those before posting. And we compiled a short list of social media content tips generally for those of you sharing on behalf of your business organizations or on your personal page, sharing stuff from your business. We have generated entire memos for companies and entities related to these, so this is just a very small sampling. Make sure that if you're posting on behalf of your organization that you have authority to do so and that you're clearly stating your affiliation at the outset of your post or on your personal page. If you post every now and then, it might be a good idea to say, these opinions are my own and not of my organization. It's a great idea as a business, if you're posting on behalf of the organization, to only post your own content that you created, not rely on works that other people have made, especially if you don't have permission to do so. And then public domain works, we've cautioned to it. If it's over 100 years old, take a pause, since it is on digital media that you're about to be resharing it, and question how it got there and the permissions for it to get there before resharing. But information in the public domain, you don't need a license to reshare. And then be cautious if you're liking, sharing, commenting, reposting on things that didn't come from the original platform. So if you see a screenshot from Twitter, someone's posted on Instagram, or you want to do that as your business, we would not recommend against that. And also recognize that taking posts and content from profiles that are intended to be private and then resharing those, screenshotting them, is also a no-no. Hashtags and content that you create should not include trademarks, entities, celebrity names of other people that you don't have permission to use. That gets into more of the trademark and right of publicity issues, but you want to steer clear of that as well. Stay generic and make sure it's content that you created and you have approval and permission to post. And then finally, in the age of fake news and fact checking, it is always great to try to post to the original source whenever possible, and go back and double check that what you're posting is actually accurate to the extent that you can check, and if you're sharing it on your public page. And then, just to reiterate some best practices, it's great to pause before posting, double check that checklist. If you've made one, we recommend one, and then seek legal advice when necessary. We mentioned some specific instances that you don't want to rely on a Google search or, a quick check, that you actually do need some legal advice. So recognize when those are to help protect yourself. And then finally, we're coming up on our last poll question here. Believe it or not, today was meant to be an overview of some high-level topics. I know we did talk about a lot of details, but we've identified some potential future topics. I know some of you in the questions have already requested one for not music related to literary work, but if you have ideas for other webinars, these are some that we've identified, and I'll go to the poll question. If there are any of these that stick out to you that you'd be most interested in, please let us know. And there's something else. If you have some other ideas, we'd love to hear them. So this is our last poll question for the day. If you would submit that, we'll give you a few seconds here to do that. All right, a couple more seconds. Great, I think that's pretty good. Just the results. Interesting. Okay, so we have some good feedback. I think we have about a little more than 5 minutes left. I think we want to go through some of the questions.
I'll first say, Rolando, you've given us several questions, so I'm going to go through yours offline, and I'll send you, we have your contact information. I will respond to those questions directly to you. And let's see, we'll go through these, and Cindy, you can scroll through, and if we see one that we can let's see, there's got to be something in here. If you write a song and have demos that you've recorded, but use someone else's equipment for the recording, who owns the copyright? You do. It's who the performer is, not the music not the equipment that did the recording. What are the risks of, let's see, Phelan Simpkins, with the growing trend of marketing on socials like Instagram and TikTok with their libraries and the allowance of users to upload, what are the risks and issues of remixing, stitching, duetting, these types of content? All those things are creating derivative works. You're remixing it, you're making changes to it, and it is going to depend on if you're within Instagram and the original stuff is posted to Instagram and it's covered by the Instagram library, it may be covered by the Instagram agreements. It's not an easy question to answer. It is not absolutely okay, and it may not necessarily be not okay. We would need to look at the situation. I'm sorry, lawyers say that all the time, but the answer is it depends.
The other thing to mention on that too, specifically with the TikTok and the stitching, there are certain features available on the business platform and the personal platform, and you can't take something from the business platform, one of the features that's available, and then go post that on your business page if you have both. They're very limited, especially on TikTok, on what you can do on the business platform versus the personal one as well. So that has a factor.
Okay, and we've got one here. Joseph Greer, does an archival recording, a recording made by an organization solely to create a historical record of the performance, not for distribution, require a sync or a mechanical license? Most likely not. Now, if you're making the archival recording, most likely there's probably an agreement in place. A lot of times with these performances and stuff, the agreement's going to cover the taking and recording of an archival copy. If it's not dealt with in that agreement, and they don't want you to take a recoverable copy, then maybe you aren't able to. So the answer is you may not necessarily need, quote, a sync or mechanical license, but the overall agreement for that performance should include that you're allowed to make an archival copy. Let's see, I think we're coming up on the end here. Let's see, are DJs that play music that does not belong to them at house parties or small-ish events violate copyright law? Yes, they can. And is this generally accepted because it's not enforceable? I don't know that it's not enforceable, but maybe it's one of those things. Am I still speeding if the cop doesn't see me? It's still infringement. If nobody turns you in, then I suppose you can, then you're not going to get in trouble with it. But if it's, in a larger place, or if you're using music and word gets out or something comes up, it could come back at you. The fact that you don't get caught doesn't mean that it's not infringement. So that's just a risk that, people take.
All right.
All right. So, Sydney, do we have some final things we need to say, or how do we turn this off? Again,
Yes. I have a closing script. Thank you all for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And thanks again. That concludes our webinar.
And we will answer all the questions separately offline.
Yes, we'll follow up. Thanks so much.